Vicarious liability in law of torts means a legal rule that holds a person or a company responsible for actions committed by others or by their employees. This principle is based on two legal maxims, named as a respondeat superior, which means let the master answer, bqui facet per alium facet per se, which means he who acts through another in law it is deemed to be done by himself. It has three kinds of relationships by which a person who has not committed any wrong will be held liable. A master-servant relationship. Here master will be held liable for the act committed by the servant, but it is necessary that the servant must have done the same in the course of employment. Here now let us understand who is a servant. A servant is a person employed by another to do work under the directions and control of his master. As a general rule, a master will be held liable for the tort of his servant, but he will not liable for the tort of independent contractor. Case, Syama Devi versus State Bank of India. In this case, the plaintiff has given some money to his friend who was working as an employee in SBI, but the plaintiff's friend misappropriated the sum of the money she has been given to. So, the plaintiff sued the defendant under the principle of vicarious liability. The court held that while the plaintiff gave the money to the friend, he was not under the course of employment. Therefore, the defendant will not be held liable under the principle of vicarious liability, be partners. In that situation, the necessary condition is that of being partner of some firm or any other business. Case, Lloyd versus Gray Smith and Company. In this case, one of the partners of the company made a client to sign on gift deed in spite of a sell deed. The defendant took the defense that it was not him but his partner who did the same, but the court held him liable as it was their company and they were partners in the same. See principal and agent. It is the situation when one entity authorizes another to perform actions on their behalf. For example, he's the agent of the Bank B and he was authorized to go for a deal in a meeting on behalf of the Bank B. And while attending the meeting, if it commits to do some contract with Bank C, then Bank B is bound to perform the contract, but if he refuses to perform and Bank C suffers harm, then the Bank B can be sued by Bank C, but not the agent because he was working on behalf of the Bank B.